Hearing in the appeal of James-Bowen and others, and the Commissioner of Police for the Metropolis.
Yes, Mr. Warren.
May it please my lady, I appear on behalf of the appellant in this appeal alongside my learned friend, Miss Lisa Doby. My learned friend, one of Her Majesty's Counsel, Mr. Nicholas Bowen, appears with my learned friend, David Leamer, for the respondents. My lady, the appellant is, of course, now Cressida Dick. There have been various...
Yes, there were he's and she's spattered all over the...
And that's the explanation.
We understand why, yes.
My lady, my learned junior and I have prepared a speaking note which we hope will assist both in terms of the court's own note-taking and in following our submissions. If I could perhaps just hand that up.
And have you served it on...
We have.
The other
only
side?
just this morning.
Yes. Yes. Could you... That's very kind.
My lady, we've been allocated 4 hours. We're rather hopeful we won't need that long.
Well, we were discussing this
Yes.
earlier, and we thought 2 days was a very generous time estimate. It's a really serious and important issue,
Yes.
but it is a relatively short issue.
I'm certainly hopeful I'll complete my submissions within 3 hours.
Well, we'll look forward to seeing how efficient you are, and equally how efficient Mr. Bowen is.
It's unlikely.
Well, I'm giving you a warning, Mr. Bowen. Yes.
Does this overlap with, or is it additional to your written case?
It overlaps with it, is additional to it, in the sense that we took the view a speaking note might be particularly helpful because since we filed our written case, this court has, of course, handed down its decision in Robinson.
Yes.
And, my lady, what we propose to do is I'll address you very briefly, take you very briefly to the facts and the issue which falls to be decided. I'll then turn to the Robinson case. I will then take the court to the established principles we say are relevant to the current appeal. I will then deal with the implied term, then the policy reasons, then the status of the respondents as witnesses, and then finally and briefly the issue of privilege. My lady, in relation to the facts, these of course appear in the agreed statement of facts and issues, which is at MS 33 onwards. The respondents are police officers who took part in the arrest and detention of Babar Ahmed in December 2003. Mr. Ahmed alleged that he'd been seriously assaulted by the respondents, and in October 2007 brought proceedings against the appellant on the grounds that he was vicariously liable for those assaults. The appellant entered a defence denying liability, but during the course of the proceedings made unsuccessful attempts to settle the claim by way of CPR Part 36. The respondents were not parties to the proceedings, but during the course of the proceedings attended two conferences with the appellant's solicitors and counsel. And they provided witness statements, but said that they would be unwilling to provide oral evidence if special measures were not available to protect their visual identity, their names having already been put in the public domain by an IPCC investigation, Independent Police Complaints Commission. An application for special measures was made by the appellant, but was unsuccessful. The trial commenced on the 16th of March 2009. The respondents declined to give evidence voluntarily, citing the failure of the application for special measures and also a lack of confidence in the way that the defence had been conducted by the appellant and his legal team. 2 days into the trial, the appellant compromised the claim on terms which involved an admission of all but one of the alleged assaults. That compromise was embodied in a court order which can be found at MS 359. It doesn't, I'm sure the court's wondering what happened to the officers afterwards. It doesn't appear in the statement of facts and issues, but isn't contentious. The particulars of claim allege, and this is at paragraph 1 on paragraph 81 on MS 169, MS 169, and the defence admits that no disciplinary measures were taken against the officers after the settlement, and the claimants continued in their frontline roles with access to firearms. In August 2010, the CPS directed charges against the respondents for 1 count each of actual bodily harm, and in due course the respondents were tried and acquitted. 3 of the respondents remain serving police officers with the appellant. 1 of the respondents has since retired. In terms of the history of the case and the issue and the appeal, could I take the court to MS 37? The claim was originally put on a number of different bases, and we see at paragraph 22 those different bases summarised. Firstly, that a retainer had arisen between the respondents and the appellant's legal team because of assurances given to them by counsel and the DLS solicitor, which are referred to in the statements of facts and issues. Alternatively, it was said that the appellant had assumed a duty of care to the respondents by reason of those same assurances. And then it's the third basis, which is the basis which remains live, is that the appellant, as their quasi-employer, owed them a duty of care to protect their health, economic and reputational interests in his preparation and conduct of his defence to Mr. Ahmed's claim and when considering and effecting any settlement of it. Mr. Justice Jay struck all the various claims out on the appellant's application. The respondents appealed and were successful on the third of those grounds in relation to the duty which was said to be owed by the appellant as in a position akin to employer.
So the only damage which a claim is live is financial and reputational.
Yes. The judge struck out the personal injury claim, and the Court of Appeal held that was rightly struck out, applying essentially my lady's tests in her speech in Hatton and Sutherland when my lady was in the Court of Appeal.
I do remember it very well.
Yes.
As indeed do you.
Yes. Turning to where we stand in relation to what the Court of Appeal found, at subparagraph 4 on page 39 of the Statement of Facts and Issues, MS 39, the court held that the duty owed by an employer, as they arguably found it, included 2 sub-duties. One was a duty to defend the litigation brought against the appellant as effectively as possible. And the second was a duty when deciding whether to compromise the claim, and if so, on what terms, to take care not to sacrifice the respondents' reputations without good reason and without giving them reasonable warning of what he intended to do. Paragraph 28, we point out and agree that the respondents don't allege that the settlement itself or its terms breach duties 1 or 2. Rather, they allege that the appellant found himself in the position of having to settle on the terms he did because of the negligent way he'd conducted his defence up until that point. And in fact, it's important potentially to note that the respondent's claim, if this duty exists, would hold good even had the case proceeded to a judgment against the appellant, in which findings were made against them by the court. Before the lower courts, the respondents alleged that the appellant had breached that second duty, the duty not to sacrifice their reputations before settling, by telling them what he intended to do. However, the Court of Appeal held that the respondents had no real prospect of establishing that that breach had any causative effect, because the prospects of the respondents applying to be joined into the proceedings were fanciful.
What was the breach? Sorry, that had no cause.
The breach was said to be that before he entered into the terms of settlement with Babar Ahmed, he ought to have let the respondents know that he was planning to do so.
I see.
So this is breach of sub-duty 2?
Breach of sub-duty 2. So in fact, no breach of sub-duty 2 was found to be arguable on the facts in terms of causing any loss. And essentially, what one is left with is a complaint that the antecedent conduct of the defence by the appellant up until the point where he settled the proceedings, I say he because of course at the time it was he, that he owed a duty to conduct, as the Court of Appeal found it, a defence as effectively as possible. The alleged breaches of the duty are summarised in paragraph 27 of the Statement of Facts and Issues, and this is the alleged breaches of duty 1, to conduct the defence effectively. And it was said that it had been breached by failures on the part of the appellant to preserve or retrieve relevant evidence. It was said that some notebooks had gone missing. There was CCTV evidence of Babar Ahmed's arrival at the police station, which should have been deployed in the civil proceedings. And it was said that there was an MI5 probe of Babar Ahmed's house, which had picked up material relevant to the arrest and which led to the acquittal in criminal proceedings, which should have been obtained and deployed in the civil proceedings. It was also said that the respondent failed to call the right witnesses, in that there were other officers present who could have been proofed to give evidence. It was said that the respondent should have called a particular witness to deal with levels of professional standards in the use of force. And it was said that the respondent should have called suitable medical evidence to deal with the medical evidence served by Mr. Ahmed, which tended to support his case that he had suffered injuries by reason of assault during his arrest. With that background, my lady, I turn to the Robinson case, which the court will find in Volume 2, Tab 9 at MS 677. And in this case, Lord Reid, with whom my lady agreed, Lord Mance agreed in the result, if not entirely all of the reasoning. Lord Reid set out helpfully the approach to the so-called Caparo test and the approach to duties of care. And at paragraph 23, which is on MS 684, he pointed out that Caparo was a decision made in the aftermath of Annes and Merton, and that Annes and Merton had led to a period of really unrestrained liability where defendants were left having to try and argue almost impossible public policy reasons as to why a duty shouldn't be found. And Caparo had come in that context, but of course the judges in Caparo itself hadn't intended that they were laying down any revolutionary new test either. And the real emphasis from Caparo is on an incremental approach in determining whether a duty of care exists in a novel situation.
This is all presumably strictly obiter
Yes,
in Robinson, because the one thing we were saying in Robinson was that this wasn't a new situation.
quite.
Perfectly standard situation where there was a duty of care and it
Yes.
had been broken.
And it was,
Yeah.
that duty had been recognised in the various police pursuit cases and all the rest of it.
I'm not trying to decry what Lord Reid said, with which I agreed, but nevertheless,
Yes.
we have to
No, and I think
accept that it's strictly obiter.
he acknowledged it was not strictly necessary, I think, when he went on to make these points. But they are helpful and they do reflect the attitude taken by Lord Toulson in the Michael appeal as well. And he, at paragraph 25 and 26, 25, he sets out the passage from Sutherland Shire Council and Hayman, to which we've referred in our case, encouraging the development of novel categories by reference to decided categories of cases. And at paragraph 26, he makes the point my lady's referred to, that there are many situations where a duty clearly is established. And then at 27, he says it's normally only in a novel type of case where established principles do not provide an answer that the courts need to go beyond those principles in order to decide whether a duty of care should be recognised. And following Caparo, the characteristic approach of the common law in such situations is to develop incrementally and by analogy with established authority. The drawing of an analogy depends on identifying the legally significant features of the situation with which earlier authorities were concerned. And the courts also have to exercise judgment when deciding whether a duty of care should be recognised in a novel type of case. And it's that exercise of judgment in those circumstances that involves a consideration of what's fair, just and reasonable. As Lord Millett observed in Macfarlane and Tayside, the court is concerned to maintain the coherence of the law and the avoidance of inappropriate distinctions if injustice is to be avoided in all other cases. But it is also engaged in a search for justice, and this demands that the dispute be resolved in a way which is fair and reasonable in accords with the ordinary notions of what is fit and proper. And then paragraph 29, he sets out how Caparo thus achieves the balance between legal certainty and justice. And in the ordinary run of cases, courts consider what has been decided previously and follow the precedents, unless it's necessary to consider whether the precedent should be departed from. In cases where the question whether a duty of care arises has not previously been decided, the courts will consider the closest analogies in the existing law with a view to maintaining the coherence of the law and the avoidance of inappropriate distinctions. They will also weigh up reasons for and against imposing liability in order to decide whether the existence of a duty of care would be just and reasonable. The current case was recognised by the courts below as being novel, and certainly neither your appellants nor your respondents have been able to find any decided case in this jurisdiction or even other common law jurisdictions. We've looked at Canada, the United States, Australia, New Zealand, where a duty of care has been held to exist in these circumstances. It's true that an employer's duty to protect his employee from personal injury is well recognised. But duties to protect an employee from economic or reputational harm have been recognised in only very limited and strictly defined circumstances. The respondents refer to some of the cases, and I'll come to them later. We say, and this is at paragraph 9 of the speaking notes, so it's noted there, that the following principles militate against the existence of the duty alleged in this case. Firstly, the law does not generally impose conflicting duties or create conflicts of interest. Secondly, the law respects the rights of litigants acting in good faith and in accordance with the rules of the court to litigate their disputes as they please without incurring a liability and negligence to others. Thirdly, the point I've just made, the law does not generally impose an obligation on an employer to protect his employee from harm which does not constitute personal injury. Exceptions to that rule are rare and strictly defined. And fourthly, in the particular context of the police, a chief constable owes no duty of care to an officer in relation to whom he brings misconduct proceedings. Turning to conflicting interests, the case we've referred to in our written case, in which I'll take the court to first, is D and East Berkshire. It's at volume 1, tab 5, MS 515. My lady will, of course, be familiar with this case, having sat in the Constitution of the Court of Appeal, which heard it. The case arose in the context of allegations of child sexual abuse, and the question was whether doctors and, in one case, a social worker who were investigating such allegations and examining the children owed a duty of care to not just the child, which was accepted for the purposes of the appeal in the House of Lords, but also to the parent. The House of Lords appeal was concerned solely with the position of the parents, and the court held by a majority, Lord Bingham dissenting, that no duty of care was owed, that the child was the doctor's, or I suppose one might say the social worker's, the person was patient, not the parent. The duty was to act in the best interests of the child, and that the imposition of a duty of care in relation to the parent would potentially conflict. Lord Nichols' speech at paragraphs 85 to 88 on, page, I'll give you the MS reference, MS 548. MS 548, paragraph 85. Lord Nichols said, in his view, the Court of Appeal reached the right conclusion on the issue arising in the present cases. Ultimately, the factor which persuades me that a common law interference with family life does not justify according to a suspected parent a higher level of protection than other suspected perpetrators is the factor conveniently labelled conflict of interests. A doctor is obliged to act in the best interests of his patient. In these cases, the child is his patient. The doctor is charged with the protection of the child, not the protection of the parent. The best interests of a child and his parent normally march hand in hand, but when considering whether something does not feel quite right, a doctor must be able to act single-mindedly in the interests of the child. He ought not to have at the back of his mind an awareness that if doubts about intentional injury or sexual abuse prove unfounded, he may be exposed to claims by a distressed parent. He then goes on to say, of course, that one would expect doctors in the ordinary case not to be swayed by that, and he acknowledges doctors often owe duties to more than one person. For instance, a doctor may owe duties to his employer as well as his patients. But he says the seriousness of child abuse as a social problem demands that the conflicting duties should not be imposed. Paragraph 88, he said that the claimant sought to met that conflict of interest point by noting that the suggested duty owed to the parents has the same content as the duty owed to the child, namely to exercise due skill in care and investigating the possibility of abuse. And that is echoes with what the Court of Appeal said in this case, that the duty essentially was just a duty to conduct a defence carefully for the appellant's benefit, and therefore was the same. But Lord Nichols said that response is not adequate. The time when the presence or absence of a conflict of interest matters is when the doctor is carrying out his investigation. At that time, the doctor does not know whether there has been abuse by the parent, but he knows that when he is considering this possibility, the interests of parent and child are diametrically opposed. The interests of the child are that the doctor should report any suspicions he may have, and he should carry out further investigation and consultation with other childcare professionals. The interests of the parents do not favour either of these steps. This difference of interest in the outcome is an unsatisfactory basis for imposing a duty of care on a doctor in favour of a parent.
Well, that sums it up precisely, doesn't it?
It does.
In that particular context,
Yes.
it does. And I think that is the answer that he gave to Lord Bingham's.
Yes,
approach.
it is. Lord Bingham was heralding a potential shift away from a duty of care to a breach analysis that didn't find favour with the majority. If I could just draw the Court's attention very briefly to paragraphs 109 to 110, Lord Roger. He again, at paragraph 109, pointed to the fact that counsel for the appellants was anxious to present their case as one where a duty to the child and duty to the parents coincided, and therefore sought to...
Could we have a page reference?
Oh, I'm so sorry. MS 555 MS.
Thank you very much. Thank you.
But that bland version of the supposed duty underplays, if does not eliminate, what I would regard as the most powerful element in the case for the appellants, that by concluding that the children had been the subject of abuse or deliberate harm, the doctor simultaneously indicated that the appellants themselves had been responsible for the abuse or harm. And of course, one can draw parallels with the position of the employer, where he concludes that, in fact, the allegations against his employee may be true, or at least may be established in the civil proceedings. In paragraph 110, he said, in considering whether it be fair, just and reasonable to impose a duty, a court has to have regard, however, to all the circumstances, and in particular to the doctor's admitted duty to the children. The duty to the children is simply to exercise reasonable care and skill in diagnosing and treating any condition from which they may be suffering. In carrying out that duty, the doctors have regard only to the interests of the children. Suppose, however, that they are also under a duty to the parents not to cause them psychiatric harm by concluding that they might have abused their child. Then, in deciding how to proceed, the doctors would always have to take account of the risk that they might harm the parents in this way. This would be not one set, but two sets of interests to be considered. Acting on and persisting in a suspicion of abuse might well be reasonable when only the child's interests were engaged, but unreasonable if the interests of the parents had also to be taken into account. Of its very nature, the duty would cut across the duty of care to children. But we say that's also true in the case of an employer who faces a claim, because at the outset of the proceedings, the employer doesn't know whether there may be something in the allegation of abuse which is made against the employee. And if a duty is to arise, as my learned friends suggest, essentially at the outset until some identified actual conflict arises, then from the outset the employer has to look at the case through the prism not just of the employer's interests or the interests the employer may owe more generally, such as in this case the general functioning of the MPS, but has to be looking at it through the prism of the employee's interests.
But where the doctors are investigating allegations of sexual abuse on children by their parents,
Yes.
the conflict between a duty owed to the child and a duty owed to the parents is much more stark than in your case.
Yes, it's certainly the child abuses identify the point. The child abuse cases identify the point starkly, but in fact, what I'll be submitting is they reflect an underlying principle in the law, and indeed one picks that up from Lord Brown's speech. Just in passing at paragraph 126, he quoted with approval a passage from the Court of Appeal's decision, which referred to the fact that there was a potential conflict. Failure to remove a child can give rise to a valid claim by the child. The same is not true of the parent's position. It will always be in the parent's interest that the child should not be removed. Thus, the child's interests are in potential conflict with the interests of the parents. In view of this, we consider there are cogent reasons of public policy for for concluding that where childcare decisions are being taken, no common law duty of care should be owed to the parents. That paragraph one...
When one's got an abuse situation,
Yes.
the first thing is, did abuse take place?
Yes. But in a sense, that's...
Has there been damage? The second thing is, who did it?
Yes.
And so the doctor may have no idea
Yes.
who did it. So that is certainly the case in one or two of the
Yes.
cases that were involved in the Dee and Berkshire situation. It was a question of whether there had been a non-accidental injury to a
Yes.
child. And the question of who might have done it. So the conflict can be at one remove.
Yes. I mean, here, of course, one has allegations of abuse against the officers.
Yes.
And the employer doesn't necessarily know. These weren't the only officers who attended at the premises. Indeed, they weren't the only. The particulars of claim brought by Mr. Ahmed didn't name these officers, but named officers, just simply alleged that officers generally had attacked him. And the employer doesn't know at the stage when he's having to decide his stance in the litigation, or indeed throughout the litigation, positions are constantly kept under review. The employer doesn't know if there may be something in the allegations. The employer, of course, has to make his own assessment of how good a witness he thinks the person who is accused is going to be. And if one had a duty owed to the employee, one can foresee the difficulties which would arise because the employer at that first meeting with the employee is having to approach the litigation on the basis that if he takes the view that the employee may have done it, he may face further proceedings later from the employee. If he announces halfway through a conference, for instance, to the employee that actually having considered matters, he thinks that there's a conflict of interests between them because they have different ways of thinking about how the defense should be run, or something that the employee has said, then that's not in itself going to be conducive to good employee-employer relations.
It may, in some contexts, be against the public interest to actually pursue a defence of the employee. I mean, if the employees really have been involved in abuse, it's presumably in the public interest for the employer to reveal this and to protect the public by doing so.
And that's a particular concern, of course, for police forces.
Yes. So, I mean, I suppose that's the analogy with East Berkshire.
Yes.
In a sense, as a public interest, which means that you can't always take account of the parent's interest because the child's interest, or here the public interest, must prevail.
Well, the employee's interest will always be in having their name cleared.
Yeah.
And certainly we will all have sat in conferences where employees are very enthusiastic about fighting cases where employers are less so. But the employer's interests have to be broader by definition because the employer is the party to the proceedings. The employer is the party at the end of the day who faces the judgment and the costs risk in proceedings. The employer also has to take account of wider interests such as the employer's own reputation.
I don't know whether it ever happens. This is the sort of situation in which, for which intervention is also appropriate, isn't it? I mean, if you feel that your interests are going to be prejudiced, you could presumably, it may never happen as an employee, apply to intervene.
Yeah, it seems unlikely any employee would ever intervene because, of course, by intervening, they're putting themselves potentially on risk for all the damages and costs that would follow.
That was why it was said that it was a fanciful...
Yes.
Completely implausible in this case that they would have intervened, given that they had wanted to be screened in the first instance.
Yes.
But were an employer, to take an example far removed from the circumstances of the present case, where an employer concludes on the basis of the evidence that he has assessed that the accused employees did not commit the harm that they're accused of, but nevertheless considers that there are supervening circumstances in which it is appropriate to settle the case, and that thereby the employees are exposed to reputational damage, is there any liability on the part of the employer in those circumstances?
Well, we say not, because
so he can wantonly expose his employees to allegations, or to the proof of allegations which he knows to be untrue.
Well, the word wantonly is very loaded because
it is deliberately so.
We're concerned here with the case of alleged negligence, and a theme which runs through our written case, I hope, is that situations may be different if an employer is behaving in bad faith and essentially using the litigation as an instrument of oppression. That may well be
well,
different.
Throw wantonly and ignore bad faith. Let's suppose the employer considers that it's in his interests to admit liability where he knows that the underlying factual matrix does not in fact exist, and thereby exposes employees to reputational damage.
Well, in my submission, he is entitled to admit, because the difficulty is it's the employer who's the actual party to the proceedings. And civil litigation, as we all know, is not is not predictable. And nobody can ever say that a case is 100% liable to succeed. But the employer is the party who faces the cost risk. The employer is the party who faces the damages risk, and the employer has other wider interests to take into account. Because if this principle is right, it applies not just to police forces, but it applies to people who employ a nanny, because my learned friend seeks to draw a duty on the basis of a duty that exists and is implied into all contracts of employment.
That would be a duty that would exist between a solicitor appointed by an insurer to act for an insured and the insured, isn't it? As a groom and crocker type duty.
Yes. And of course, the difference in that situation is that the insurer provides a complete indemnity to the employer, so the interests are in fact aligned, and of course there'll be a complex policy document which will set out everybody's rights and obligations in the event that people disagree with the conduct of the claim. I mentioned that in answer to my Lord Wilson, that although the principle is quite stark in child protection cases, it is still a principle which applies more widely. And I was going to refer to what Lord Brown says at paragraphs 134 onwards, and MS 563. Paragraph 134, he said it, having referred to the difference in situation where a child dies and somebody is accused of abuse, both causing psychiatric injury to a parent. He says, if it can be said that in the second case the father's reputation is blackened, the law's response must be that a defamatory communication in the context of reporting suspicions of child abuse would inevitably attract the defence of qualified privilege, so that liability would only arise in proof of malice, not mere negligence. The reason for such a rule is obvious. The law is concerned to encourage candour in such communications. Doctors should not feel inhibited in reporting their concerns. And then he deals with Spring and Guardian. He says, I acknowledge this principle did not prevent the House from finding a duty of care owed by an employer to his employee with regard to the preparation of a reference, Spring and Guardian, but the speeches of the majority clearly emphasise the importance to that decision of the employer-employee relationship. In fact, as decision last week from this court emphasises the real point in Spring and Guardian, and I'll come to it later, is the assumption of responsibility, which was undertaken in that case. Ordinarily, when considering the imposition of a duty of care previously unrecognised by the law, and I do rely on this, the courts are astute not to create a conflict of interest. And then he makes reference to the rather different context of cases White and Jones and solicitors and lawyers' liability. And then at paragraph 136, He refers to the related situation to that presently under consideration as where a doctor prepares evidence with a view to appearing in a child abuse case as a witness. In this event, of course, an absolute immunity or privilege attaches to his evidence. Not for a moment do I suggest that this was the position in any of these cases. The Court of Appeal examined and rejected such a claim on behalf of the social workers in the Dewsbury case, and no appeal arises as to that. The point to be made, however, is that the public interest in law enforcement and the administration of justice does sometimes require potential liabilities to be excluded, notwithstanding that those wronged are left uncompensated. And then, just for the Court's note, I refer to paragraphs 136 and 137. 137, in fact, is worth commenting on because he makes the point that it's not an answer to say that, well, liability will only be found where someone has acted unreasonably, because that overlooks the effect of the conflict from the outset. And secondly, it overlooks the fact that the person making the decision needs to be protected against the risk of costly and vexing litigation, by no means invariably soundly based.
It's a bit wider, isn't it, even? I mean, if you did away, if you simply said, well, fine, you can always avoid liability by acting reasonably, wouldn't be any need for the concept of duty of care at all.
And that was the position Lord Bingham was moving to in this case,
yes.
Which would be the end of tort law, certainly in the branch of negligence. The same principle in relation to conflicting interests underpins the lack of duties of care in other circumstances. One is the duty of care, the fact that the prosecutors, although they act as ministers of justice rather than necessarily adverse litigants, don't owe a duty of care either to victim or suspect. And at paragraph 11 of our speaking note, we've referred to SXH and against the CPS, which this court decided last year. And it's at volume 5, tab 45, MS 1645. This was actually a case under the Human Rights Act, and the appellant, or so the claimant had been detained on the basis of not having the right entry documents, when in fact she had a very valid claim to enter the country as an asylum seeker. And her contention was that the decision to prosecute her for an offence under the Immigration and Asylum Act amounted to a breach of her rights under Article 8 of the Convention. My lords, Lord Manson, Lord Kerr, were in the case, the panel that heard the case. The passage I particularly draw attention to, however, is a passage from Lord Toulson at MS 1655, where he considers what the position is at common law. And at paragraph 37, he referred to El Ghazouli Daff and the Commissioner of Police for the Metropolis, and Brooks and Commissioner of Police Van Call and the Chief Constable of Hertfordshire, and Michael and the Chief Constable of South Wales. And in El Ghazouli Daff, two claimants were arrested, charged and remanded in custody for some weeks before the CPS discontinued proceedings against them. In the first case, the claimant contended the CPS was negligent in failing to act with due diligence in obtaining the results of forensic evidence which showed him to be innocent. In the second case, the claimant contended it should not have taken the CPS 3 months to conclude that the prosecution was bound to fail. In both cases, the Court of Appeal upheld decisions striking out the statements of claim. Lord Justice Steyn, as he then was in the leading judgment, said that a citizen who is aggrieved by a prosecutor's decision has potentially extensive remedies for deliberate abuse of power. But the court rejected the argument the CPS should owe a duty of care towards those it decided to prosecute. And then importantly, at paragraph 38, the duty of the CPS is to the public, not to the victim or the suspect, who have separate interests. To recognise a duty of care towards victims or suspects or both would put the CPS in positions of potential conflict and would also open the door to collateral interlocutory civil proceedings and trials, which would not be conducive to the best operation of the criminal justice system. Similar decisions are relevant when considering the applicability of Article 8 in the context of a decision to prosecute. So again, one finds this reference to the potential conflict, excluding the existence of a duty of care. And it is also, of course, also one of the reasons why there is a lack of a duty of care owed by opposing parties, both in litigation, but also in non-contentious work. That lack of a duty recently having been considered, my Lord Wilson's speech in Steele and Enram, handed down by this court last week, and I'll come back to Steele a little later, if I may. And we say in our speaking note that the rule applies to potential as well as actual conflicts for good reason. And this is paragraph 13 of the speaking note, which is it promotes certainty. To require an actual conflict to develop turns the question into whether there was a duty on particular facts. And of course, there may be disputes as to when an actual conflict arises. And importantly, the freedom of action of the person said to owe the duty would be inhibited from the outset.
Before I forget, can this speaking note be emailed to the
Yes, of course.
office, please?
I'll make sure that's done at the end of the day.
Thank you.
And as we say at paragraph 14, if a duty was to be owed, it would mean that from the outset, the employer's own freedom of action would be compromised. Instead of being able to assess the strength of the case dispassionately and the employee's likely performance, any sensible employer will be concerned not to expose himself to further litigation. We've identified what we say the conflicting interests are in our case. And I've given the reference there in the speaking note. But essentially, I think I've covered them already. The employer's interests are much wider and more financially directly at stake than the interests of the employee. But we also draw attention to the fact that interests may also conflict between employees, because actually it's not uncommon, particularly when a large employer is sued, and it's certainly the case in relation to the police, that different witnesses give different accounts. And we give the example of the Mohideen case, and it's a decision at first instance, but it's perhaps helpful as a reference. It's volume 4, tab 38, MS 1424. It was a case where the Commissioner of the Police for the Metropolis was sued for alleged assaults perpetrated by various officers. It was tried by Mr. Justice Gilbert, and Mr. Justice Gilbert found that some of the allegations made by the claimants were good. The Chief Constable had brought Part 20 proceedings under the Civil Liability Contribution Act against the officers concerned and sought damages from them. So one sees at 1427, MS 1427, the nature of the sorts of complaints. Mr. Mohideen alleged that he'd been taken into a van and assaulted by PC Mark Jones, who swore at him and abused him. Mr. Hegacy made allegations about a search, and Basil Khan alleged he'd been wrongfully arrested and assaulted. And at paragraph 14, the judge referred to the fact that the defendant adopted a sort of neutral stance in the claim, And he said he had to do so by saying this was a case where the defendant was unable to assert a positive case about what had happened in the van, as one of his serving officers, PC on Wigbono, gave evidence which supported the case for the three claimants. And the other parties were also serving officers. And one was still a serving officer who did not support the case for the three claimants, as were other officers. So it's an illustration, perhaps, of the sort of thing that happens on the ground, and to whom is the employer's duty to be in such circumstances? The officers who are accused of misconduct by the claimant, or the officers who give an account which doesn't support their fellow officer. The case also highlights, of course, a point we make in our written case, that underlying all this, of course, is that there is the potential in any case for a claim under the Civil Liability Contribution Act 1978. And that act, of course, proceedings may be brought at any point up until 2 years after the original claim is either settled or disposed of by way of judicial finding. And what's notable, another point we make about that act, is it's notable that if one turns to it, and it's in volume 2, at MS 840, MS 840. That act at section 1.4 on MS 841, so it's volume 2, tab 12, allows a person who has agreed or made a settlement in bona fide settlement or compromise of any claim against him in respect of damage to recover a contribution without regard to the fact whether he himself was ever liable for the damage, provided he would have been liable, assuming that the factual basis of the claim could be established. So in other words, a person alleged to be vicariously liable for the tort of another is entitled to enter into a settlement. The court will not inquire into whether that was a reasonable settlement, only whether it was made bona fide. And we say that sits rather uneasily with the duty alleged in this case as well.
Well, there is a proviso that he would have been liable
Yes.
if the factual basis alleged against him
Yes,
established.
but he doesn't have to have been liable. So if the allegations in the statement of claim disclose a viable cause of action, then the person who's on receipt of the claim is entitled to settle it and then seek contribution. Where the disputes on this provision tend to arise is if the person on the receiving end of the contribution proceedings says that the facts alleged in the particulars of claim didn't disclose a viable cause of action in the first place.
Well, isn't it more likely that the person from whom contribution is sought will accept that the facts alleged disclose a viable cause of action, but say, actually, the facts alleged aren't true?
Yes, and they're entitled to do that.
Of course they are, yes, because they're not...
They're not bound by
I'm not
that.
liable because you settled on a false premise, even though you acted reasonably.
And that, of course, reflects the principle that civil litigation is in personam litigation, which only binds the parties to it.
Right.
But it does rather make the point that where somebody has settled in good faith, there's not an inquiry into whether it was reasonable for them to settle, which the respondents...
Well, what's a bona fide settlement? I mean, does that not have an element of... Does it have no element of reasonableness?
Well, I suppose one might have circumstances where you argued that a settlement was so unreasonable, you paid damages that were way in excess of anything that could potentially be awarded, where you might say, you might infer that was done in bad faith, and allege that wasn't a good faith settlement.
In Muhyiddin, there were contribution proceedings.
There were contribution proceedings in Muhyiddin, and indeed the officers were ordered to provide a 100% indemnity. If I could turn to the second established principle on which we rely, which is the general entitlement on parties to conduct litigation as they please, provided they act in accordance with the rules of the court and in good faith. We start this on page 6 of our speaking note. And the context, of course, starts with the absolute immunity which applies to things said or done in legal proceedings. Now, just to be clear, we are not saying that the respondent's case here engages absolute immunity insofar as it relates to the antecedent conduct of the defence. It would have engaged absolute immunity had it attacked the terms of the settlement, which were embodied in a court order and made in court, or had it attacked a judicial finding, which had resulted if the settlement hadn't been made.
But the investigative failures are alleged to have taken place after the litigation was commenced.
Yes.
Yes. So, and what's this Darker case?
Darker, which is at volume 3, tab 24, MS 1040, was a case where the police were sued in misfeasance of public office and conspiracy for allegedly fabricating evidence. And the police sought to argue that the claims in misfeasance and conspiracy couldn't lie against them because the officers would have given evidence in support of their fabricated evidence in court, and therefore it was protected by the absolute immunity which applied to judicial proceedings. Lord Hope very helpfully defined the absolute immunity which applies to judicial proceedings at page 1050. MS 1050, and it's at the beginning of his speech, letter H. He said, when a police officer comes to court to give evidence, he has the benefit of an absolute immunity, and this immunity, which was regarded as necessary in the interests of administration of justice and is granted to him as a matter of public policy, is shared by all witnesses in regard to the evidence which they give when they are in the witness box. And it extends to anything said or done by them in the ordinary course of any proceedings in a court of justice. The same immunity is given to the parties, their advocates, the jurors, and the judge. Of course, the reference to advocates needs some qualification now. They are all immune from any action that may be brought against them on the ground that things said or done by them in the ordinary course of proceedings were said to be done falsely and maliciously and without reasonable and probable cause, see Dawkins and Lord Rokeby. The immunity extends also to claims made against witnesses for things said or done by them in the ordinary course of such proceedings on the ground of negligence. No challenge is made in this case to what may be conveniently be described as the core immunity. It is not suggested that police officers who participate in the proceedings as witnesses should no longer have the benefit of it with regard to things said or done by them while they're actually in the witness box. The question that has been raised relates to the further extent of the immunity. Where are the boundaries to be drawn? And then that arises because it's another factor that must always be balanced against the public interest in matters relating to administration of justice. It's a principle that a wrong should not be without a remedy, and any derogation from that right of access to court which requires to be justified. At the bottom of the page, letters G, he quotes from Silcott and the Commissioner of Police to identify the basis underlying, the policies underlying the absolute immunity. The public policy purposes underlying the immunity are essentially twofold. First, per Lord Justice Fry in Munster and Lamb, to protect persons acting bona fide who, under a different rule, would be liable, not perhaps to verdicts and judgments against them, but to the vexation of defending claims. Second, as Lord Wilberforce said in Roy and Pryor, to avoid a multiplicity of actions in which the value or truth of their evidence would be tried over again. And then he goes on to say the second of these two policy reasons applies only to the core immunity and is limited in its application to things said or done in court. And he goes on to refer to Roy and Pryor and Lord Justice Ilde's dictum that the whole point of the first public policy reason for the immunity is to encourage honest and well-meaning persons to assist justice, even if dishonest and malicious persons may on occasion benefit from the immunity. And Lord Hoffman and Taylor, and the Director of Serious Fraud Office, is designed to encourage freedom of speech and communication in judicial proceedings by relieving persons who take part in the judicial process from fear of being sued for something they say. Lord Hutton also referred to the terms of the immunity at MS 1068, 1068, page 463 of the report. Letter G, he said that the rule that a party or a witness has immunity in respect of what he says or does in court has been established for centuries. He refers to Cutler and Dixon. And I don't think I need to read that out. But over the page at letter B says the rule was succinctly stated by Kelly, CB, and Dawkins and Lord Wilkie. No action lies against parties or witnesses for anything said or done, although falsely and maliciously and without any reasonable or probable cause in the ordinary proceedings of a court of justice. And he goes on to set out at letter D that the reason for the rule is grounded in public policy. It is to protect a witness who has given evidence in good faith from being harassed and vexed by an action for defamation brought against him for words he's spoken, and if the protection were not given, persons required to give evidence in other cases might be deterred. Now, as I say, we don't say this is a case of absolute immunity, but it provides the context within which the claims arise. And as I said, had the case been criticism of the terms of the settlement order, that may well have, and we say would engage absolute immunity. But the underlying policies which underpin the rule and absolute immunity do have some purchase in relation to the sort of claim that the respondents seek to make.
I mean, this case deals with conspiratorial conduct,
yes,
venting evidence with a view to the commencement of criminal proceedings. Yes. In other words, it's before.
Yes, and that's why the claimants succeeded in that case, because
whereas we are actually dealing with
the conduct of
proceedings.
Yes. Yes, the court drew a distinction between the police performing their investigatory function and the actual evidence gathering process in the context of the litigation.
Particularly clear from Lord Hutton's judgment,
yes,
where he sets out the facts in full. Yeah.
Yes. So that's area one to which we refer. But that feeds into the next point we make, which is the general absence of any duty of care owed by one litigant to another, at least absent any specific assumption of responsibility. And in relation to this, we start the story with Al-Kandari and Brown, which is in volume 2 at tab 19, MS 906. I'm sorry, it's not at tab 19. It's
It is. It is.
Oh, it is. I'm sorry. And this was a case where, in fact, a duty was imposed on a solicitor because, in the context of family proceedings, the solicitor had given an undertaking.
Oh, this is the passport case?
Yes.
Yep.
He was acting for the father. The children's passports were effectively the father's passport. He gave an undertaking to the court that he would keep the passport safe in order to prevent the father taking the children out of the country, but negligently he released the passport to the father. And it's one of
My
those cases.
recollection is that very recently my Lord Wilson has gone through all these cases.
He is. I'm going to come to that. I should maybe have
The
gone there
Northern Rock
quickly.
case, yes.
Could I just very briefly look at this, and then I will bring the case of Steel and Enram to the court. At 672A on page MS 913, Lord Donaldson set out the general rule to which this case was an exception at letters A to C, and said at letter C that in the context of hostile, inverted commas, litigation, public policy will usually require a solicitor to be protected from a claim in negligence by his opponent. And then at Lord Bingham at 675 MS 916 sets out at letter G that in the ordinary course of adversarial litigation, a solicitor does not owe a duty of care to his client's adversary. The theory underlying such litigation is that justice is best done if each party, separately and independently advised, attempts within the limits of the law and propriety and good practice to achieve the best result for himself that he reasonably can, without regards to the interests of the other party. The duty of the solicitor within the same limits is to assist his client in that endeavour, although the wise solicitor may often advise that the best result will ordinarily involve an element of compromise or give and take or horse trading. Ordinarily, however, in contested civil litigation, a solicitor's proper concern is to do what's best for his client without regard to the interests of his opponent. Could I turn to the Steel and Enram case, because Lord Wilson does helpfully review the authorities in it.
But what do you collect from this line of cases about the general lack of a duty by one party to litigation to the other? What do you collect of value to your own submissions in this rather different scenario?
Well, two things. First of all, I collect the underlying public policies which apply, which encourage people to be able to come to court uninhibited from suffering the vexation of further proceedings, and also the underlying public policy against satellite litigation. So I do collect public policies. The conflict point, of course, also features. And of course, in a sense, in this case, although there were no proceedings between the respondents and the appellants, there could have been. The fact that there weren't actually proceedings doesn't mean that this wasn't a case where there could at some point have been proceedings.
You can add, perhaps, to this little group of authorities a case from a rather different area of the law called Manifest Shipping, the Star C in 2003 Appeal Cases 469, where the House of Lords held that in a claim under an insurance policy, the mutual duty of good faith switched off once litigation has begun. In other words, in litigation, the controls are
the
by
process
the
of the court,
and you can't stand up in the course of the trial and say that was a breach of the duty of good faith by putting in this witness statement or relying on this evidence.
You mean not only good faith, but utmost good faith?
I mean utmost good faith.
Verify.
Yes.
That's a helpful point, which sadly we've missed. But I will.
It's an insurance lawyer's point.
Name of the case?
We will.
It's called Manifest Shipping, and the vessel's name is the Star Sea.
We'll endeavour to make sure we get copies of that case.
It's 2001 UKHL 1 or 2003 Appeal Cases 469, and I think it's principally Lord Hobhouse's judgment. I may be wrong about that.
In the Steel and Enram case, my Lord Wilson was considering a claim brought by a lender, essentially alleging that they'd relied on the borrower's solicitor and a representation made by the borrower's solicitor in terms of discharging the security which the lender held. And of course, when the lender came to enforce its security, it discovered that the money had gone. And the Supreme Court, Lord Wilson, with whom my Lady Hale and Lord Reid and Lord Hodge and Lady Black agreed, held that absent a specific assumption of responsibility, the claim had to fail. And my Lord reviewed at paragraph 18, case we've referred to in our case, Customs and Excise and Barclays Bank, where Lord Mance had said that the case of Headley Byrne was the fountain of most modern economic loss claims. And at paragraph 24, I think I should mention this because my learned friends rely on Spring and Guardian. My Lord considered Spring and Guardian, which was the case where a reference was written for the claimant who had worked for the employers and he was now seeking work elsewhere. And the court held that the defendants owed a duty of care to him. And Lord Gough explained that the basis of his conclusion was the defendants had assumed responsibility to the claimant in respect of the reference within the meaning of the Headley Byrne sense. And then weeks later, Henderson and Merritt was decided in relation to the underwriting agents owed a duty of care to a member in their conduct of his underwriting affairs, even in the absence of a contract. And again, reference to Lord Gough, that the case should be decided by reference to the concept of assumption of responsibility. And in Williams, A Natural Life, Lord Steyn remarked that there was no better rationalisation for liability in tort for negligent misrepresentation than the concept of assumption of responsibility. The court considered at paragraph 25 that therefore the legal consequences of the solicitor's careless misrepresentation are clearly governed by whether in making it she assumed responsibility for it towards Northern Rock. And this concept fits the present case perfectly, and there's no need to consider whether there should be an incremental development of it. Nevertheless, the case has an unusual dimension, for the claim is brought by one party to an arm's length transaction against the solicitor who is acting for the other party. A solicitor owes a duty of care to the party for whom he is acting, but generally owes no duty to the opposite party, Ross and Coulters. The absence of that duty runs parallel with the absence of any general duty of care on the part of one litigant towards his opponent, see Jane and Trent. And then my Lord went through 6 authorities, including Al-Kandari and Brown, making good that point. And at paragraph 32, my Lord said, perhaps it helps only slightly for us to have been reminded in the authorities cited above that Miss Steele and the firm are liable to Northern Rock only if it was a special case. Probably of greater assistance is the analysis in the Al-Kandari case that the solicitors owed a duty of care to the opposite party because they had stepped outside their normal role. But the 6 authorities demonstrate, in particular, the solicitor will not assume responsibility towards the opposite party unless it's reasonable for the latter to have relied on what the solicitor said, and nonetheless the solicitor should have foreseen that that's what he would do. The third collection of authorities we refer to in this point is the malicious prosecution, abuse of process cases, which I think all members of this panel but one have considered in various guises. In one of 2 cases, the Privy Council case of Crawford Adjusters and Sagicor, and also the Supreme Court decision in Willers and Joyce. And if I could just briefly go to some passages in those cases. Crawford Adjusters and Sagicor is in volume 1 at tab 2, MS 383. And it was a case which arose out of insurers maliciously prosecuting a surveyor. And of course, the issue to be decided by the courts was whether the tort of malicious prosecution lay in civil proceedings or if it only applied to criminal proceedings. And by a majority, the court ruled that it did apply to civil proceedings. Much of my Lord Wilson's judgment is taken up with an historical analysis as to whether the tort had hitherto, in the distant past, been understood to apply to civil proceedings, and in difference from Lord Sumption, my Lord, and the majority concluded it had. At paragraph 49 on page 389, my Lord referred to Saville and Roberts, and if I could just draw attention to what my Lord said at letters between...
what page was it again?
Page MS 406, I'm sorry.
Thank you.
Yeah. Between letters C and D, Lord Wilson said, in my view, the best encapsulation of the central decision in Saville and Roberts, which makes no distinction between criminal and civil proceedings, is to be collected from the report at 5 Mod 5394 as follows. It is the malice that is the foundations of all actions of this nature, which incites men to make use of law for other purposes than those for which it was ordained. And at paragraph 55, my Lord referred to that decision being cited by Parker C.J. in Jones and Given, where D had unsuccessfully prosecuted C for exercising the faculty of a badger. It's a great term, i.e. the right to deal in corn without a license. And C successfully sued D for malicious prosecution and relied equal to his costs of £100. And Parker C.J. reiterated that an action would lie for the malicious prosecution of civil proceedings if the claimant could show special matter which shows malice.
How are we helped by this area of the jurisprudence?
Well, what I say we get from it is, and particularly when one looks at the speeches from the minority, which my lords considered, the minority referred to some of the public policy reasons which applied, and my lord and my lady and Lord Kerr, although disagreeing with the application of those policy proceedings in relation to the tort of malicious prosecution in civil proceedings, recognised the force that some of those policy objections would have had, but for the fact that malicious prosecution requires the element of malice and the lack of reasonable cause. In other words, some of the concerns that, for instance, my Lord Mance expressed in the Willers and Joyce case may have had a different purchase had the allegation been that a claim could lie for the negligent prosecution of proceedings. That's what I collect from it.
Very well.
Surely, certainly Willers and Joyce, Lord Toulson went out of his way, as I recall, to address a point I'd made in my judgment about the scope of malice and to indicate that it was closely confined.
Yes, and I think one may find that if one turns to Willers and Joyce. So I'll leave, having made, well, before I leave Crawford and Sagakor, can I just draw attention to some remarks my lady made at MS 418.
That's where I started.
Yes.
Can't think I said anything interesting.
Well, we submit it is relevant because you said that it's always tempting to pray and aid what's...
Oh,
Lord Bingham said that the first
I see.
rule of public policy has...
Begs the question of what's wrong.
Yes. Some conduct is wrongful whether or not it causes any damages, and that's the essence of torts or torts of trespass. Other conduct is only wrongful if it causes particular types of damage. and that's the essence of an action on the case, but not all conduct which causes such damage is wrongful, and the tort or torts of wrongfully bringing legal proceedings are actions on the case, and therefore can only lie if there is damage of the kind specified in Saville and Roberts. But that is not enough. Instigating legal proceedings in good faith and with reasonable cause, even if they fail and even if they do damage, in the Saville and Roberts sense, is not wrongful. Even maliciously instigating legal proceedings is not always or even often wrongful. So how is the wrong done by instituting legal proceedings to be defined? And my lady said it would be understandable if there were no such wrong at all. And you cite the two policy reasons about people not being deterred from investigating criminal charges or bringing lawsuits. It doesn't, and then you referred to your dissent along with Lord Hope's in Jones and Caney, and said that second, once proceedings are over, the court should not be troubled with further claims. And clearly it cannot be open to every successful defendant.
Mr. Warnock, please don't let your voice drop too much.
I'm so sorry.
I know you're trying to get through it very quickly, but nevertheless, it's important to be heard.
You said clearly it cannot be open to every successful defendant to round on his own successful claimant or prosecutor, no matter how great the collateral damage. Defining the circumstances in which he can do so is fraught with difficulty, as this case shows. Hence, both of the principal policy reasons for declining a remedy, in this case, which would support the denial of any remedy to anyone. But you then go on, my lady, to agree that this is in fact a recognised tort. But I also draw attention to what my lady said at paragraph 84, where at letter H, 3 lines up from the bottom, you said, this too is a case which is particularly well suited for judicial development. It is about the use and misuse of judicial proceedings. The law is entirely judge-made, and some would say it's in a judge-made mess. But I rely on that in relation to the suggestion that the Court of Appeal made that these matters aren't matters suitable for resolution except by reference to a trial.
And then there's Lord Kerr at 101.
Yes.
That might be worth articulation expressly.
Yes. My Lord Kerr said, and I particularly rely on what he says on the fourth paragraph. This is MS 423. Sorry, the third and fourth sentence. Manipulation of the legal system lies at the root of the tort. The underlying reason for immunity is what is said or done in litigation is surely the need to protect litigants who legitimately use the legal system to have perceived wrongs redressed or claims resisted. It should not be used as a charter for improper resort to legal proceedings to achieve an aim unrelated to their professed purpose.
And at 103, he deals with the argument, oh, well, we really can't have too much collateral or consequential litigation.
Yes. And he points out at letter C that the evidential difficulties faced by a litigant seeking to establish the ingredients of malicious prosecution would militate strongly against the pursuit of pointless litigation.
Yes.
So again, it's the requirement of malice which meets the policy objection. And finally, in relation to my Lord Kerr's speech, if I could draw attention to the fact he considered if there is a tort, whether or not there could therefore be a tort of malicious defence, and although not deciding the issue, clearly left open the possibility that there could. Again, no suggestion, however, that there could be a cause of action for a negligent defence. In Willers and Joyce, Volume 2, Tab 11, MS 783, when the same issue came back to the Supreme Court, if I could just take the court first to Lord Mance's dissenting speech. And at MS 812. And at paragraph 93 on MS 812, Lord Mance says the Supreme Court must also engage closely with legal policy, is, I think, clear. Viewed in isolation, the assumed facts of this case make it attractive to think that the appellant should have a legal remedy, but the wider implications require close consideration. We must be aware of the risk that hard cases make bad law, and we are entitled to ask why, until the Privy Council's majority decision in Crawford, there has been an apparent dearth of authority in this jurisdiction for a claim such as that which the appellant wishes to pursue. And at paragraphs 131 to 135, MS 827, Lord Mance deals with the policy issues and says, we can ignore the first one at 131, but at 132, the recognition of a general tort in respect of civil proceedings would be carrying the law into uncharted waters, inviting fresh litigation about prior litigation, the soundness of its basis, its motivation, and its consequences. And we say that dictum is very apposite to the claim sought to be made in this case. And at paragraph 133, my Lord made the point that logically any such tort would extend to any individual application or step in the course of the civil action. Of course, in this case, it would apply to the special measures application to gain time or to avoid execution rather than for genuine litigational purposes. And my Lord said, logically, once the parties are exposed to claims for maliciously pursuing their respective case, there's no real reason why witnesses should not be likewise exposed. And then at 134, letters D to E, having referred to Lord Wilson's judgment in Crawford, Lord Mance said, in my opinion, such evidence, this is of the deleterious effects that allowing the claim might have, could hardly be expected, and such actions have long been seen as impossible. In any event, the formation of legal policy does not normally depend on statistics, but rather on judges' collective experience of litigation and litigants, and more particularly here, their appreciation of the risks involved in litigation and the risks of its misuse. Judges have enough experience of disingenuous behaviour and procedural shenanigans on the parts of litigants to form a sound policy, view of policy in this area. And then my Lord referred to the clear recognition of the need that civil actions should in general be litigated without risk of one or another party or a third party subsequently being able to go over and claim in respect of anything said or done in such actions. And that's the absence of the duty of care. And there we are guilty of not picking up my Lord's reference to the manifest shipping case.
Yes. Which I had forgotten.
Lord Toulson, going to the majority speech, MS 800, MS 800, paragraph 44, referred to the policy concerns. And first of all, he dealt with floodgates and said it suggested that although his claim might be meritorious, there's an unacceptable risk of being followed by other claims which are unmeritorious. And the argument that a good claim should not be allowed because it may lead to someone else pursuing a bad one is not generally attractive. But in this case, it is bolstered by two other arguments, the deterrence factor and the finality factor. But in relation to deterrence, his lordship referred to Saville and Roberts, referred to the deterrence costs provides. But then at letter C says, we can always hypothesize that an honest litigant who has not been put off from bringing a claim by the risk of a judge wrongly deciding he had acted improperly and making an indemnity costs order might nevertheless be put off from an extra risk of an opposing party bringing a vindictive action. But there's no way of testing the hypothesis, and it seems intrinsically unlikely. In relation to finality, there is unquestionably a public interest in avoiding unnecessary satellite litigation, whether in criminal or civil matters, but that has not been considered a sufficient reason for disallowing a claim for malicious prosecution of criminal proceedings. Unlike certain other forms of satellite litigation, an action for malicious prosecution does not amount to a collateral attack on the outcome of the first proceedings. In fact, this type of action might well involve a collateral attack because if there's a duty to conduct an effective defence, then that duty can be sued on, presumably whether the case settles or goes to trial and results in adverse findings against witnesses who are put into the witness box and who may say that such findings could have been avoided had only the litigation been conducted differently. Then in relation to inconsistency with the lack of a duty of care, and this may be the point my Lord Mance was referring to earlier, at paragraph 49, he said the distinction, this is letter D, the distinction between careless and intentional conduct is a familiar feature of parts of the common law, reflected in Oliver Wendell Holmes Jr.'s often quoted saying, even a dog distinguishes between being stumbled over and being kicked. No.
Why, even a dog?
One doesn't like to think what Chief Justice Wendell did to his dogs.
Oh, he did have.
But he was certainly a fine jurist. And so there, that paragraph 49, the emphasis is on the great difference, letter C, between imposing a duty of care and imposing a liability for maliciously instituting proceedings without reasonable or probable cause. And then at paragraph 51 in passing, he mentions it doesn't necessarily follow that there would be an action for a malicious defence. Those are my submissions in relation to the conduct of litigation point. The next point we make, and it's page 8 of our speaking note, is that the well-established duty of an employer to his employee relates to personal injury. And we refer to Crossley and Faithful and Greenway and Johnson, which I'll come back to because the submissions here overlap with the submissions on the implied term. But as my learned friends point out in their case, there are exceptions. And one is the Malik case, which again I'll be coming to. And the other is where an employer has assumed a specific duty of care. And that's the Spring and Guardian case. And at paragraph 36, I don't think I need to take my lords to it unless you would find it helpful. We summarize the decision in Spring and Guardian. Lords Lowry, Slynn and Wolfe decided the case on a Caparo analysis. Lord Gough, whose approach we would submit as the one that's found favour subsequently in the cases, would have decided the case on the basis of Headley-Byrne assumption of responsibility because the employer decides to give a reference and in doing so is undertaking a specific duty to provide it carefully. And Lord Lowry would have agreed with him. Three of their lordships, Lords Gough, Slynn and Wolfe, also considered a term could be implied into the contract of employment, that if a reference was to be supplied for the employee, due skill and care would be exercised in its preparation. But Lord Wolfe set out very specific factors which enabled the term to be implied, and perhaps we should look at those at MS 1618. It's volume 4, tab 43. Volume 4, tab 43, and the passage from Lord Wolfe at MS 1618. At letter H, he said it was possible in that case to specify circumstances which would enable a term to be implied. The circumstances were the existence of the contract of employment, the fact that the contract relates to an engagement of a class where it's normal practice to require a reference from a previous employer before employment is offered, and the fact that the employee cannot be expected to enter into that employment except on the basis that the employer will, on the request of some prospective of another prospective employer, made not later than a reasonable time after the termination of a former employment, provide a full and frank reference. And then he goes on to say, that being the nature of the engagement, it's necessary to imply a term.
Is that still the position? Do people, in fact, have an entitlement to a full and frank reference? If you have reservations, I thought that it was quite common simply to give a statement that somebody had been employed from X that date to that date. And
that is indeed one of the consequences of Spring and Guardian.
Yes, but this suggests that you owe actually. Well, perhaps the answer is you only owe the duty to the employee, and so he's not going to complain if you
don't say anything.
Don't say anything.
But it is
an inference.
Certainly, most of the references one sees these days are indeed very bland and just confirm the dates of employment, and very little beyond that.
Yes.
What we say about Spring and Guardian, I should say in Customs and Excise and Barclays Bank, my Lord Mance, at MS 512, referred to Spring and Guardian, and it's MS 512, it's volume 1, tab 4. At 512, letter H, my Lord referred to Spring and Guardian and said the relevant regulatory regime did no more than impose an obligation to obtain and give a reference of a familiar type, which a former employer would commonly give, irrespective of any compulsion. It would have been incongruous if a duty of care was owed when such a reference was not given under compulsion, but was absent just because it was. Further, if the reference had been unduly favourable, the recipient's reliance on it would have introduced an element bringing the situation closer to that in Headley Burn, and it would have been strange if a duty were not owed to the subject of an unduly unfavourable reference, given that the duty would be owed to the person receiving it. And I've already drawn attention to my Lord Wilson's explanation of the Spring case in the decision in Steele and NRAM. And then we draw attention to the fact that, of course, in this case, the Court of Appeal and the judge dismissed the allegation that there was any assumption of responsibility by the appellant, a finding against which there is no cross-appeal. The final established principle point we make arises out of the decision in Calverley, and the Chief Constable of Merseyside. We deal with this on page 9 of our speaking note. And Calverley, police officers who had been made subject of misconduct proceedings by their respective chief constables alleged that those misconduct proceedings had been conducted negligently. They'd taken too long, essentially, weren't done efficiently enough, and by reason of that they had suffered economic and reputational damage, and in one case personal injury as well, in one case. And Lord Bridge, the House held no duty of care was owed to them, and the cases in Volume 1, Tab 1, MS 369. And sorry, I've not been giving the full citations, but it's the 1989 appeals cases.
Don't worry about that.
But Lord Bridge at page 1238, which is MS 379, MS 379. referred to the fact that leading counsel for the appellant submitted that a police officer investigating any crime suspected to have been committed, whether by a civilian or a member of a police force, owes to the suspect a duty of care at common law. It follows he submits that the like duty is owed by an officer investigating a suspected offence against discipline by a fellow officer. It seems to me that this startling proposition founders on the rocks of elementary principle. The first question arises, what is injury to the suspect ought reasonably to be foreseen by the investigator as likely to be suffered by the suspect if the investigation is not conducted with due care, which is sufficient to establish the relationship of legal neighbourhood or proximity, in the sense explained by Lord Atkin and Donoghue and Stevenson, as the essential foundation of the tort of negligence. The submission that anxiety, vexation and injury to reputation may constitute such an injury is only to be stated to be seen as unsustainable. Likewise, it's not reasonably foreseeable that negligent conduct of a criminal investigation would cause injury to the health of a suspect, whether in forms of depressive illness or otherwise. And then he said at letter F, finally, all other considerations apart, it would plainly be contrary to public policy, in my opinion, to prejudice the fearless and efficient discharge by police officers of their vitally important public duty of investigating crime by requiring them to act under the shadow of a potential action for damages for negligence by the suspect, and if no duty of care is owed by a police officer investigating a suspected crime to a civilian suspect, it's difficult to see why any conceivable reason why a police officer who is subject to the investigation under the regulations shouldn't be in any better position. And that case was considered by Lord Reid in Robinson. If I could just briefly go back to it, volume 2, it's MS 695. It's volume 2, tab 9. And the MS 695 Lord Reid referred to the submission made by the Commissioner in that case as relying on 5 authorities, the first of which was Calverley.
Sorry, paragraph?
Paragraph 56. In which police officers who had been suspended pending the completion of disciplinary proceedings sought damages in respect of an alleged failure to conduct the proceedings expeditiously. They claimed to have suffered damage to their reputation, depression and a loss of earnings. They alleged that they were owed a duty by the investigating officers to exercise proper care and expedition in the conduct of the investigation. It was argued that a police officer investigating a suspected crime owes a duty of care to the suspect, and that the same principle applied to the investigation of a disciplinary offence. The House of Lords rejected the argument. Lord Bridge pointed out that claims of negligence founded on the rocks of elementary principle, the passage we just looked at. The losses claimed, so far as non-financial, were not reasonably foreseeable, and the financial claims ran up against the formidable obstacles in the way of liability and negligence for purely economic loss. Lord Bridge added that all other considerations apart, it would be contrary to public policy to prejudice the fearless and efficient discharge by police officers of their vitally important public duty of investigating crime by requiring them to act under the shadow of potential civil action. Reliance was placed on the latter dictum, but it is of no assistance to the respondent in the present case. Lord Bridge's remark has to be understood in its context. The case sought to establish a novel type of liability relating to the manner in which an investigation was conducted, and Lord Bridge's reference to policy considerations was directed to that claim. He was not addressing the question whether the police may owe duty to avoid causing reasonably foreseeable physical injury in the course of their operations. Now, what we draw from Calverley is, it seems, a rather incongruous result if a chief constable who brings disciplinary proceedings against his officers comes under no duty of care to them, despite having taken that positive action. Whereas here, it is said by the respondents a duty is owed for merely failing to defend proceedings brought not against the respondents themselves, but against the chief constable alone.
Well, yes, but Calverley is another case of opposition.
Yes.
The investigating officer and the investigated officer.
Yes.
This is, again, it's not so stark.
But in terms of what we say in terms of the coherence of the law, it seems a rather remarkable position that here where the Chief Constable makes a positive case against the officers or brings proceedings but fails to conduct them expeditiously, no duty is owed, whereas in merely failing to defend, he does come under one. I accept it's not if there were a case that was stark enough to cover this situation, we wouldn't all be here, I suspect.
Yes.
But there might be. I mean, I think you made the point earlier that one could posit a case where certain police officers said one thing,
Yes.
and the officers, in respect of whose conduct the Chief Constable was being sued, said
Yes.
another thing.
Quite.
And then you would get the same sort of conflict.
Exactly, and we say that, and we also say that some of the allegations in this case, such as failing to discover or adduce the probe in the that the security services had apparently put in place, they come fairly close to allegations, although they're made in the context of a duty said to relate purely in the context of litigation. They sound rather like allegations of negligence in policing as well.
At the end of the day, what is said to have happened is akin to an allegation of a disciplinary offence. In other words, it's said that by settling in the terms they did,
Yes.
they were in effect saying these officers have done something wrong.
Yes.
So it's not very much less stark,
No.
perhaps.
In relation to, my learned friend says an answer, and if necessary I'll come back to this more in reply. Well, that's all very well, but Waters and the Commissioner of Police for the Metropolis provides an answer, because in that case, an officer alleged she'd been raped by another officer, and there had been, she alleged that subsequent to that she was the victim of harassment by other officers. But there, the House of Lords held, it's MS 1659, if one wants to look at it, MS 1659, Volume 5, Tab 46. The facts appear sufficiently from the head note at 1659, MS 1659. The officer alleged she'd been sexually assaulted, and she brought a writ alleging that her employers had, as Chief Constable, had failed to deal adequately with protecting her from the harassment and so forth which followed. And the court held that it was arguable that the defendant owed duties to a police officer under his direction and control analogous to those owed by an employer to an employee, and if he knew that acts were being done or might be foreseeably done to the officer by fellow officers might cause her physical or mental harm and did nothing to protect her against such acts, he might be in breach of duty. And it wasn't plain, public policy ruled it out. Of course, the thing to note about this case is it was a personal injury claim for failing to protect the officer from harassment she was suffering at work, so it fell within an arguably established duty situation. And that point appears from Lord Slynn's speech at at MS 1665, where he distinguished Hill and Calvary. At letter E 1665, he said it's true that one of her complaints is the failure to investigate the assault on her, and that, if taken alone, would not constitute a viable cause of action. But the complaints she makes go much wider than this, and she, in any event, is not suing as a member of the public, but as someone in an employment relationship with the defendant. Even the failure to investigate is part of her complaint as to that. Entirely different factors to those engaged in Hill's case arise. She is not, as in Calverley's case, complaining of delays in the investigation or procedural irregularities. It does not seem to me it's an answer here, as it was in Calverley's case, to say that she could proceed by way of judicial review. Here there's a need to investigate detailed allegations of fact.
Well, that's got to do with whether it's a strikeout situation.
Yes. But the essential point about this case was it was a case about a failure to protect a serving officer from personal injury in the way that she was being treated by other officers. And that's at 1663. Lord Slynn said at letter B, if an employer knows that acts being done by employees during their employment may cause physical or mental harm to a particular fellow employee and does nothing to supervise or prevent such acts when it has the power to do so, it's clearly arguable that he was in breach of duty of care, breach of duty to that employee. But there's certainly no suggestion in Robinson by Lord Reid that Calverley is in any way wrongly decided. My lady, with that I turn to the alleged implied term. And this is page 10 of our speaking note. And by way of introduction, we point out that the term has been described by Lord Nichols in Mallock as a portmanteau allegation. But as we say at paragraph 47, the question is whether within that portmanteau it contains an obligation on an employer to conduct competently an effective defence of proceedings brought against the employer alone for the benefit of his employees. That's the ultimate obligation which has been alleged here.
If you can't establish an assumption of responsibility, is it easier or more difficult to establish an assumption by contract?
But it must be more difficult. Unless they've got express terms in a contract. I mean, one of the difficulties we say about this alleged term here is, that is, how does one define it? Because one only needs to state an obligation to conduct an effective defence to see the problems which arise. What is an effective defence? In some cases, an effective defence may be defending the case on causation or focusing on causation rather than breach of duty. In other cases, an effective defence may be making an effective Part 36 or other settlement offer at an early stage and doing better than it. In other cases, one might say an effective defence is just to get the best.
Aren't these all the factors which go to duty of care? Just
well, they do. We say
in a contractual context. Are we talking here about a term which is implied by law into this type of contract, or are we talking about the more general test of necessity of implication?
We're talking about the former. What my learned friends say is, of course, there is no contract here, and indeed, if one goes back to the particulars of claim, one won't find any plea of an implied term of trust and confidence. But my learned friend says that by analogy, and this was the point that seems to have found favour with the Court of Appeal, although they don't expressly say it, that by analogy with positions where there are contracts of employment, there is a standardised term of trust and confidence. And the argument that's put is that that standardised term embraces within it the facts that we've got on this case.
Well, one might not find it too difficult to conclude that there was an implied term of trust and confidence into this quasi-employment situation. Not too difficult, so to conclude. But the big question would be whether the implied term of trust and confidence, which is in every employment contract, includes this particular duty.
Quite. It's a question of
that's the big question.
It's a question of the scope of the implied term, because it is, as a portmanteau allegation term, it consists of different parts. And the question is this part?
And of course, it cuts both ways. It's a mutual obligation. So one would have to ask, well, what obligations did the quasi-employees or employees owe to their employer to cooperate in the effective defence?
Yes. So or indeed, if they alone had been sued for something to conduct the proceedings in the interests not just of themselves, but also of the employer.
So it's not an employment contract, but the argument you're addressing is that there is nonetheless a contract by implication, an implied contract.
But there's no
a very limited range of things.
Yes. What I'm seeking to is meet the argument against me, but there's no contract here because the police officers are, of course, constitutionally officers of the Crown.
Well, then there's nothing to imply anything into.
No,
but this is all by way of analogy.
This is all by way of analogy. What is said
Paragraph
is...
33 of his judgment, Lord Justice Morbeck said, yes, there's no contract, but it's arguable that trust and confidence come into it. Therefore, they must come into it as duties owed in tort.
Right, that's what...
And then he made the point that Lady Hale has just made. But given all that, from this can spring this particular duty.
And that's what
I mean, it may be that actually analysis of trust and confidence won't get Mr. Bowen all that far.
But we say it doesn't, because we say that when one looks at what the term involves, it clearly doesn't extend to the negligent conduct of litigation brought against the employer alone. Whilst we accept, of course, that although police officers are not employees, in many ways they have a relationship akin to employment, that actually, as we say at paragraph 49, the lack of a contract points to the scope of an employer's obligation to protect his employees, and there's a stray apostrophe there, from harm lying in tort rather than contract. And we summarise our submissions on this at paragraph 50, which we say is that the scope of an implied term to protect an employee from harm is no wider than that which would exist in the tort of negligence. And also that the scope, because it is a standardised term, is subject to considerations of reasonableness, fairness and policy. And certainly if the implied term of trust and confidence can't be allowed to run wild and result in massive extensions of the law. And thirdly, a term imposing a duty to conduct an effective defence is really impossible to define for the reasons I've just given. And fourthly, on a specific point in this case, we draw attention to the standard operating procedures which governed all the officers in this case, and it's at MS 33, which provided that the civil actions unit of the appellant sets the strategy and makes the decisions on malfeasance claims as to whether or not a claim should be challenged or settled, and if so, how much. So the term seems prima facie inconsistent with that. And thirdly, we say that the cases where the implied term has been held to be engaged and or breached are really very different, and they involve cases where there was either bad faith, such as Malik and Eastwood and Magnox, or positive action taken by an employer directed to the very continuance of the employment relationship, and examples include My Lady's decision in Gogay in Hertfordshire, McCabe in Cornwall, Yap, or other cases where the implied term provides an aid to construction of another contractual term. And again, a case My Lady gave a judgment in Braganza and BP is an example of that. So turning to the authorities, Malik is at volume 1, tab 8. And it's MS 643. And the facts were, there's the BCCI case, the assumed facts were that BCCI had been run as an entirely fraudulent organisation, but the particular claimants were entirely innocent of any wrongdoing. And they alleged that whenever BCCI hit the buffers, as it were, that when they suffered stigma from having been associated with working for what was a fraudulent enterprise. And the court's holding, as summarised in the headnote at letter H, was that there was an implied obligation on an employer that he would not carry on a dishonest or corrupt business. And if it could be shown that it was reasonably foreseeable that in consequence of corruption there was a serious possibility of damage, then liability could be established. But it's important to note that an implied obligation not to carry on a dishonest or corrupt business was the particular facts of Malik. The term was considered by Lord Nichols at MS 656, where he considers the implied term of trust and confidence. MS 656, letter H, at the bottom of the page. And he said, in the Court of Appeal and in your Lordship's house, the parties were agreed that the contracts of employment of these two former employees each contained an implied term to the effect that the bank would not, without reasonable and proper cause, conduct itself in a manner likely to destroy or seriously damage the relationship of confidence and trust between employer and employee. And then at letter D, when considering the argument in that case about the scope of the term, he said these questions are best approached by focusing first on the particular conduct of which complaint is made. The bank operated its business dishonestly and corruptly. On the assumed facts, this was not a case where one or two individuals, however senior, were behaving dishonestly. Matters had gone beyond this. They had reached the point where the bank itself could properly be identified with the dishonesty. This was a dishonest business, a corrupt business. And he asks himself, would an employee have been entitled to say, I treat the contract as repudiated in those circumstances? And the answer is intuitively yes. And at letter H, he says, 2 points can be noted here. This is 657. First, as a matter of legal analysis, the innocent employee's entitlement to leave at once must derive from the bank being in breach of a term of the contract of employment, which the employee is entitled to retreat as a repudiation by the bank of its contractual obligations. That is the source of the right to step away from the contract forthwith. In other words, and this is the necessary corollary of the employee's right to leave at once, the bank was under an implied obligation to its employees not to conduct a dishonest or corrupt business. This implied obligation is no more than one particular aspect of the portmanteau general obligation not to engage in conduct likely to undermine the trust and confidence required if the employment relationship is to continue in the manner which the employment contract implicitly envisages. And in concluding remarks on MS 664, Lord Nichols added some cautionary comments. The first one was in relation to opening doors of speculative claims and so forth, but the second one on page MS 665, letter C, I draw attention to. And secondly, one of the assumed facts in the present case is that the employer was conducting a dishonest and corrupt business. I would like to think this will rarely happen in practice. Thirdly, there are many circumstances in which an employee's reputation may suffer from his having been associated with a non-successful business or a non-successful department within a business. In the ordinary way, this will not find a claim of the nature made in the present case, even if the business or department was run with gross incompetence. A key feature in the present case is the assumed fact that the business was dishonest or corrupt. I should have said that Lords Gough and Mackay agreed with Lord Nichols. They also agreed with Lord Steyn, as did Lord Mustill. And Lord Steyn defined the term at MS MS 668, letter D. He said the applicants do not rely on a term implied in fact, in answer to my Lord Mance's point. They do not therefore rely on an individualised term to be implied from the particular provisions of their employment contracts considered against their specific contextual setting. Instead, they rely on a standardised term implied by the law. That is, on a term which is said to be an incident of all contracts of employment, see Scally and Southern Health and Social Services Board. Such implied terms operate as default rules. The parties are free to exclude or modify them, but it's common ground that in the present case, the particular terms of the contracts of the two applicants could not affect the implied obligation. And he referred at 669 to the evolution of the term, letters C to E, which arose essentially in the context of constructive dismissal cases as a means of giving the employee a remedy in the employment tribunal. And he said that letter E, the evolution of the implied term of trust and confidence, is a fact. It has not yet been endorsed by your Lordship's House. It is proved workable in practice. It's not been the subject of adverse criticism in any decided cases, and it's been welcomed in academic writings, and I regard the emergence of the implied obligation of mutual trust and confidence as a sound development. Letter, page MS 676, letter B, the effect of his conclusions. Lord Steyn drew attention to the fact that the implied mutual obligation of trust and confidence applies only where there is no reasonable and proper cause for the employer's conduct, and then only if the conduct is calculated to destroy or seriously damage the relationship of trust and confidence. That circumscribes the potential reach and scope of the implied obligation. The next case I turn to, because it picks up on this implication of standardised terms and relying on them in the context of a tort claim, is White and the Chief Constable of South Yorkshire, which is in Volume 2, Tab 10, MS 726. This was one of the cases arising out of the Hillsborough Stadium disaster. The context is the House of Lords had previously decided claims brought by the relatives of victims in the case of Alcock and the Chief Constable of South Yorkshire. But these claims were brought by police officers. In Alcock, the House had set down the criteria which would apply to successful claims by secondary victims of psychiatric injury. In White and Chief Constable, the issue was whether the police officers who were working at the stadium on the day could recover damages for the psychiatric injury they suffered, consequence on the negligence of other officers. And the House of Lords held not. But the particular interest of the case from our point of view is that some of the judges considered whether an implied term and contract would have affected the outcome. And could I take, first of all, to the dissenting in part judgment of Lord Griffiths, not dissenting on this point. At 464, which is MS 735, letters E to F, MS 735, letters E to F. The law of master and servant is not a discrete and separate branch of the law of tort, but is to be considered in relation to actions in tort generally. Here we are considering the tort of negligence and the nature of the duty of care owed by one who negligently creates a catastrophic situation. In order that there should be some limits on the consequence of the negligence for which the defendant is to be made liable, the law imposes the controls I have discussed in the Alcock case. In my view, these should apply to all those directly imperilled or who reasonably believe themselves to be imperilled irrespective of whether they are employees or not. Accordingly, I would allow the appeals insofar as the police rely on their status as employees. In fact, he would have...
You left out the not when you read that out.
Oh, did I? I'm so sorry.
It's rather important.
Yes. In my... yes. Yes. These apply to others not directly imperiled with reason. Yes. He, in fact, would have allowed the appeals of officers who were caught up as rescuers, but that doesn't matter for present purposes. Lord Gough, who also dissented, but dissented in the result more generally at 483, which is MS 754. MS 754, letters C to D. Said it's, in my opinion, consistent with the tortious basis of the employer's duty in these cases that it should, in cases concerned with a claim by an employee for damages in respect of psychiatric injury, be subject to the limits set out in the opinion of Lord Oliver in Alcock's case, in the case of a claimant who is a bystander in the sense of being no more than a passive, unwilling witness of injury caused to others. And I consider that the same could be said if the employer's duty of care was expressed as an implied term in the contract of employment. In accordance with this approach, Lord Justice Stuart Smith said in McFarlane and Caledonia, a case concerned with employees, a claim against his employer, and then he refers to the bystander principle. Now, in fact, Lord Gough would have allowed the appeals of the officers in this case because he would have held that they were caught up directly in the events and were therefore primary as opposed to secondary victims. But the important point is that he didn't see it as the relationship of employment being the relationship that made the difference as such in terms of any term of the employment contract. In Lord Staine's speech, page 768, he, at letter E, 768, said the majority in the Court of Appeal upheld the argument of counsel for two police officers that they fall into a special category. That argument was again deployed on appeal to the House. The argument was that the present case can be decided on conventional employers' liability principles, and counsel relies on the undoubted duty of an employer to protect employees from harm through work. It is true that there is no contract between police officers and a chief constable, but it would be artificial to rest a judgment on this point. The relationship between the police officers and the chief constable is closely analogous to a contract of employment, and I am content to approach their problem as if there was an ordinary contract of employment between the parties. Approaching the matter in this way, it became obvious that there are two separate themes to the argument. The first rested on the duty of an employer to care for the safety of his employees and to take reasonable steps to safeguard them from harm. When analysed, this argument breaks down. It is a non sequitur to say that because an employer is under a duty to an employee not to cause him physical injury, the employer should, as a necessary consequence of that duty, of which there is no breach, be under a duty not to cause the employee psychiatric injury. See Chris Hilson's article. The rules to be applied when an employee brings an action against his employer for harm suffered at his workplace are the rules of tort. One is therefore thrown back to the ordinary rules of the law of tort, which contain restrictions on the recovery of compensation for psychiatric harm. This way of putting the case does not therefore advance the case of the police officers. The duty of an employer to safeguard his employees from harm could also be formulated in contract. In that event, and absent relevant express provisions, a term is implied by law into the contract as an incident of a standardised contract, see Scally. But such a term could not be wider in scope than the duty imposed by the law of tort. Again, one is thrown back to the ordinary rules of the law of tort. The first way of formulating the argument based on the duty of an employer does not therefore assist the police officers. And Lord Hoffman, and I should say Lords Brown, Wilkinson and Lord Hoffman agreed with Lord Staine's speech, and Lord Staine and Lord Brian Wilkinson agreed with Lord Hoffman's speech. Lord Hoffman said it's MS 776. At letter G, referring to the argument that the officers should be treated differently because they were employees, he said, letter G 776, I think, my lords, that this argument really assumes what it needs to prove. The liability of an employer to his employees for negligence, either direct or vicarious, is not a separate tort with its own rules. It is an aspect of the general law of negligence. The relationship of employer and employee establishes the employee as a person to whom the employer owes a duty of care. But this tells one nothing about the circumstances in which he will be liable for a particular type of injury. For this, one must look to the general law concerning the type of injury which has been suffered. It would not be suggested that the employment relationship entitles the employee to recover damages in tort. I put aside contractual liability, which obviously raises different questions, for economic loss, which would not ordinarily be recoverable in negligence. The employer is not, for example, under a duty to take reasonable care, not to do something which would cause the employee purely financial loss, e.g. by reducing his opportunities to earn bonus. The same must be true of psychiatric injury. There is no reason why, if the employee would otherwise have been regarded as a secondary victim, the employment relationship would require him to be treated as a primary one. The employee in Walker and Northumberland County Council was in no sense a secondary victim. His mental illness was caused by a strain of drudgery work, which employer required him to do. So what we draw from that case is that in this area, instead of looking for implied terms in the law of contract to define what the scope of an employer's duty is, the analysis lies in the law of tort. I don't need to take the court to Johnson and Unisys. In that case, it was held the scope of the implied term couldn't extend to losses following from the manner of a dismissal, as that would cut across employment legislation. But my learned friends do rely on the cases of Eastwood and Magnox and McCabe and Cornwall, both heard together by the Judicial Committee of the House of Lords. Volume 3, tab 27, MS 1092. And it's important to note the facts of these cases at MS 1092. The first case, the employee sought damages for stress-related illness and inability to work, alleged to have been caused by a campaign on the part of the defendant employer to demoralise the claimants before dismissing them in breach of the implied term of trust and confidence. The second case involved, that's Mr. McCabe's case, a suspension of a teacher for 5 months by the employer without any reason being given during that 5-month period for the suspension. And at MS 11111, Lord Nichols, at paragraph 5, referred to the history of the implied term of trust and confidence, and referring to the use of it in the employment tribunal, he says, about just above letter E, from here it was a short step to recognise that both parties to an employment contract owe a duty to conduct themselves in a way which will enable the contract to be performed. And so that's an important description of the term. Lords, at paragraph 11, he said, Mr. Johnson, referring to the Johnson and Unisys case, he said, this is MS 1112, Mr. Johnson's claim was not without attraction. The trust and confidence implied term means, in short, the employer must treat his employees fairly. In the conduct of his business and his treatment of employees, he must act responsibly and in good faith. And Lord Steyn on MS 1125, 1125, paragraph 50. Lord Steyn said on the hearing of the present appeals, the House did not have the benefit of oral argument on the potential scope of the implied obligation of trust and confidence, or what Sir Nicholas Brown Wilkinson, Vice-Chancellor, as he then was, said in Imperial Group Pension Trust and Imperial Tobacco, more simply called the implied obligation of good faith. Perhaps it would be conducive to clarity if the latter description is generally used. The Eastwood and McCabe line of cases we say are really rather different. Eastwood is essentially a case of bad faith conduct, trying to get rid of the employee. McCabe is a case where the employer actually takes steps with a view to bringing the employment relationship to an end by bringing disciplinary proceedings. YAP and the Foreign and Commonwealth Office is another such case, but it is, if I could just draw attention to what Lord Justice Underhill said in that case at paragraph 120. It's MS 1743, volume 5, tab 49. The court may recall that Mr. Yap had been the United Kingdom's ambassador to Belize, and he was rather precipitately recalled home following an allegation made by an opposition politician in Belize about his conduct. And he alleged that he'd suffered psychiatric injury as a result of the way he had been treated. And the courts held that there had indeed been a breach of duty, albeit that the claim for psychiatric injury could not succeed because foreseeability of it was not established. And the courts also held that there was technically a breach of his contract. But at paragraph 120, Lord Justice Underhill referred to the fact that the case had been argued both by reference to the duty of care not to cause your employee harm and the so-called Malik duty not to undermine the trust and confidence of the employment relationship. And at paragraph, subparagraph 5, just above 120 on MS 1743, he said in claims for breach of the Malik duty, of course, or any other express contractual term, the contractual test of remoteness will be applicable, see Deadman. But as appears from Croft, and indeed from the present case, it will often be possible for the same conduct on the part of an employer to constitute both a breach of the common law duty of care and a breach of another contractual duty, most obviously the Malik term, but perhaps also an express term. This overlap can lead to a regrettable complexity in the formal analysis. It may be that further thought needs to be given to whether the Malik term really has any separate role to play in this area. The court in Croft seemed to think not, but it may be that the problem does not matter much in practice where there is a breach of a duty of common law care can be established. It is not clear what the employee gains by formulating a distinct contractual claim. So some unhappiness expressed by his lordship about the term complicating proceedings. In fact, it doesn't seem that he was referred to White and the Chief Constable or cases which suggest that really in this area of the law, it's tort which founds the extent of the duty when one's looking at a standardized term of this nature.
White is sometimes known as frost, isn't it?
It is, and indeed, confusingly, on the head note, it's called White, and then on every other page of the report, it's called Frost.
Absolutely, but neither is listed in the list of authorities.
No.
In YAP.
And it may be his lordship would have drawn some comfort had he been referred to that. I noticed the time. I'm about to turn to Crossley and Faithfully and Greenway.
Well, you've got
Time.
9 minutes.
We'll press on. Crossley and Faithful Holdings is in Volume 1, Tab 3, MS 453.
Does your machine say 1252? Yeah.
And this was a case where the employee sought to argue that there was an implied term in his contract that his economic interests should be protected. The facts were that he was retiring on ill health grounds, and if he had but known it, if he had retired in the correct way, that he was entitled to the benefit of his employee's disability insurance. The trouble is that policy only applied either so long as he was employed or if he left the employment, if it had been agreed it would continue.
So by warning him that he shouldn't go.
He shouldn't go.
Because he was going to lose this benefit. Yes.
Quite. That was essentially what the particular duty alleged was. And Lord Justice Dyson, as he then was, considered the nature of the term alleged, and in his review of the authorities reviewed along the way, the implied term in trust and confidence. So at MS 461, he referred, for instance, to University of Nottingham and Ayat at paragraph 25. And over the page, at the top of MS 462, said that Mr. Justice Hart observed that this duty had consistently been applied negatively.
That looks like another disaster for my husband. In the University of Nottingham case.
I won't comment.
You seem in your case to rely quite a lot on this, but sad as it is, it really was up to Mr. Crossley to know about the terms of his pension scheme.
Yes.
And these policemen here, they say they had no capacity to influence the preparation of the trial.
It's a different case, but his lordship makes some comments which are pertinent. One of which is in relation to the scope of implied terms of this nature. And, I was saying in paragraph 25, he referred to the fact that the implied term itself had generally been used to enjoin, prohibit conduct, positive conduct rather than enjoin, not positively to enjoin conduct which would avoid damaging consequences, although the judge recognised there might be cases where it could have such a content. That paragraph 30, referring to Hagan and ICI, he referred to Mr. Justice Elias's dictum at paragraph 31, MS 6463, a concern that individual acts of negligence should not in the ordinary way constitute a breach of the duty because he didn't think it would necessarily be the interests of an employee if that were the case as well.
Well, because it's mutual.
Yes. And at paragraph 33, he held the judge was right to reject a portmanteau obligation that the employer would take reasonable care for the economic well-being of his employee. It would be a standardised term, as indeed as the term alleged here would be applied into any contract, absent evidence of contrary intention. And he, at paragraph 35 and 36, and it's really paragraph 36 that we do expressly refer to in our case, he says that with terms of this nature, it seems to me that rather focus on the elusive concept of necessity, it is better to recognise that to some extent at least, the existence and scope of standardised implied terms raises questions of reasonableness, fairness, and the balancing of competing policy considerations. And indeed, that was a dictum which found favour with my Lady Hale in the Guise and Société Générale case, which we've referred to in our case. And at paragraph 40, His Lordship referred to Spring's case and MS 466, pointing out the very narrow circumstances in which Lord Wolfe was prepared to imply a term in that case in relation to giving a reference.
It's a slightly odd term, isn't it? Because it's only broken if it's repudiatory, such as would entitle the employee to up sticks and leave.
Yes, that would.
It's difficult to think of examples of terms which operate on that basis.
I can't personally think of any.
Oh, that's a good lunchtime pursuit, isn't it?
I mean, conditions in contract are of that nature, so every breach of them is, by definition, effectively repudiatory. So I suppose that's a possible analogy.
I suppose it's always open to the repudiatory breach of contract. The employer.
But the point about this term is that not every breach of faith or impolite behaviour or failure to respect the employees constitutes a breach at all.
No, quite. It has to be something which goes to the actual maintenance of the employment relationship.
Is that a convenient time?
Well, I'll not take...
Have you finished with...
Well, I was just going to draw the Court's attention to paragraphs 42 and 43, where His Lordship countenanced against massive extensions of the law and spoke in favour of the incremental approach, which of course has echoes of Robinson in it. And that completes me on Crossley.
Thank you. Are you making good progress?
I'm making very good progress.
Good. Well, we'll look forward to hearing further progress at 2:00, and we'll adjourn now.